Não, os comentários do Kissinger a respeito do império que ele fez ao Brasil quando era. Tudo sempre criticando a falta de espontaneidade brasileira.
Mas aí, eu não sei se é felizmente ou infelizmente, só somos nós, não, né? Aqui na América
Na
Latina
América Latina
é de uma maneira geral. Bem, muito bom dia.
I'll speak in Portuguese. Okay. Professor Dominic Hasha is the translation. Translation is working, yes. If you could repeat once more, we're testing. Can you hear me, Mr. Dominic? Okay. Mr. Dominic, can you hear me? Okay. Bonjour. E,
Funciona?
okay. Very well. Good morning to all. I have the great pleasure of opening this meeting on the role of the judiciary, judicial control of the arbitration here in the National High Court of Brazil, and especially besides the participants that will be presented during this meeting, my dear friend, Justice Ellen Gracie, that was the Chief Justice in the Brazilian Federal Court and is a very well-known justice, especially for her accumulated legal knowledge and a great personal integrity and of principles. And this is the formula for a good justice. We have to join these two components and evidently to have the vocation for as a magistrate. This is the theme of great importance to the National High Court of Brazil, the STJ, and I usually say that International Arbitration Court is the STJ, the National High Court of Brazil. So we are dealing with a theme that is part of our day-to-day, especially here in the STJ. We have the presence of Dr. Andrés Jana, which is the president of Judiciary Committee of the ICCA. After we will have a panel moderated, a conference moderated by Justice Luiz Felipe Salomão here from our court. And as a speaker, the conseiller and Professor Dominic Hasha at 11:15 in a panel, a guide of the ICCA for magistrates on the interpretation of the New York Convention of '58. And finally, we will close with an intervention with my court colleague, Justice Ricardo Vilas Boas Cuevas. This intervention by Vilas Boas Cuevas will be moderated by Minister Paulo Sérgio, or Justice Paulo Sérgio Domingues. And as regards compared justice, it explains the fact why we have justice of two great sessions here of the STJ. We are split in three big chambers. First, public law. That's where we have Justice Paulo Sérgio Domingues. And a second with private law, Mr. Justice Luiz Felipe Salomão. That is part of the second session. And Justice Ricardo Cueva as well. Because the theme of arbitration is in these two sessions, but especially in the special courts. And the justices that are here are part of this group of justices that are conselheiro, that are the 15 oldest here in the STJ. And I like to finish this opening thanking once more Justice Ellen Gracie that made a great effort for this event to happen and made sure that this happened. Okay. Since it's not an adequate moment to carry out events because we are suspending events or reducing them due to the elections that we will have in the first week of October. So in this second semester, we've reduced significantly our number of events. And finally, I was saying that this event is being transmitted through YouTube, our YouTube, in both languages. And this helps a lot in spreading the events we do here in the STJ. And it's impressive how in 4 days of events, or sorry, 4 days after an event here, we've already had 30,000 access through the YouTube to that event. And I'm certain that this meeting or event about arbitration will also have a lot of attention. And YouTube allows, when the event is about compared legal systems, it's something that interests all the world, and you can access it from any country. So here in the STJ, with the control we have of access, we verify that there are access literally from all over the world. So having said that, I'd like to hand over to Justice Ellen Gracie. Thank you, President. It's a great satisfaction to be here once more in the STJ. Your Excellency gives me the joy of being here still during your presidency, with a very dynamic presidency, a governance that will be part of the history of this court, and that sought a solution for excessive litigation that affects our country. We do not have the condition to continue in the same way that litigation has been happening in Brazil. For our colleagues that come from other countries, it's necessary to indicate that there is at least one lawsuit for each inhabitant of Brazil, including the elderly, children, baby, who have not much to complain about. So all of these lawsuits already started by lawyers in terms of already seeking a higher court later. And in writing up their initial petition, they already want to put subjects that can be examined by the higher courts. This is not normal, doesn't make the system work, and it's one of the reasons why Brazil has its developed delayed. So no doubt we are very happy this opportunity about the role of the judiciary in terms of arbitration, because it's a way of letting go a little bit of this accumulated number of cases. So they seek to solve their disputes through arbitration, and it's reasonable that it be so. Originally in Brazil, Brazil was a use of arbitration.
But arbitration for the settlement of border issues, where several legal experts have made it possible for the country to border several other countries without any differences. It's a very rare case where a country has been able to shape its territory without any disagreements leading to armed conflicts. And so arbitration is part of the soul of Brazil. Commercial arbitration, which is more common and widespread, and that is already commonplace here at the higher court. This took some time to become more common here. In 2002, when the Supreme Federal Court declared the constitutionality of the law on arbitration, that's when companies, especially companies and individuals, felt free to resort to the mechanisms of arbitration without running the risk of once again submitting to the judicial branch or the courts to confirm the object of the arbitration. So for us, this date is very auspicious, Mr. President, also because today a bill is being sanctioned, a bill that you have dedicated efforts towards, a bill of law. It's becoming a law today. It will confer to this House the possibility of conducting triage of matters that effectively deserve review and attention by the justices of the higher court of justice. And so we have now achieved parity with the Supreme Federal Court. From the beginning of Amendment 45, it had already obtained or ensured the possibility of resuming something that was an old practice, arbitration from past times. But unfortunately, with the 88 Constitution, this had been eliminated. So for all these reasons, it's very fortunate that on this 4th of August, we are examining not only the role of this court, which centralizes the review of the enforcement of arbitral awards that are the object of or that are contested. It is very fortunate that this is happening alongside legislative measures that will be put into practice. Mr. President, I would also like to thank you or thank my President Andrés Jana, the president of the Judicial Committee of ICCA, who has made an effort to join us today, and also for the holding of this activity. Andrés is, like yourself, is someone who is traveling all over the world and disseminating the guide that allows judges and justices to effectively apply the New York Convention. He will speak about this, but it's been a huge effort to disseminate the New York Convention so that arbitration can be enforced throughout the world, and thus the Institute of Arbitration can be strengthened. I'd also like to thank my dear friend, Dominique Acher, a member of the Judicial Committee. He's come from Paris, and he's a long-standing member of the Cour de Cassation in France. And as a judge, he is now dedicated to something that is a bit distant from our practice. These are judges from major international courts that after retirement will serve in the courts of other countries with similar judicial systems. So Dominique is currently working in Singapore. Our friend from the Supreme Federal Court, former president of the Supreme Court of Canada. She today works in the Hong Kong court. She serves in the Hong Kong court. And also countries of the Gulf where the population is reduced and where they import judges from other countries, such as Morocco, for instance, an Islamic country, but without oil. And so the judges and magistrates from Egypt and Morocco temporarily serve in Gulf countries. So this exchange of judges is a new movement. I believe this has been in practice for the past 20 years only, but it's very interesting because it actually revives all the international judicial systems. And just to end my opening words, I'd like to thank Gonçalves and Débora Visconde, president of SEBA, who have participated very strongly in the organization of this event. So once again, thank you, Your Excellency, and taking the opportunity to extend my greetings for your excellent management. Thank you, Madam Justice Ellen Gracie. The mandate as president of a court in Brazil is it's a 2-year office, and Justice Ellen Gracie was a president for 2 years. Like myself, we are in favor of not expanding the duration of this office, because 2 years is the necessary time. It's time enough to do what is needed. And it is necessary to give to other colleagues the opportunity with their own personal styles to continue the work. So here at the Higher Court of Justice, we have 5 former presidents who are members of the Grand Chambers. And the return to the jurisdiction, the president of the STJ is left without jurisdiction. And so that's very good. And we, as myself as president, I miss debating and especially voting on the most relevant matters that are examined by the court. At the Supreme Federal Court, the president votes in the plenary and also participates in the debates, but it's different here at the STJ. So for those who love the law, like myself and other colleagues, to be a president entails this fact that it is not possible to vote and to debate. So I will return. I've been here for 20 years. I will be able to once again be a full judge or justice at the STJ. And we have been able to approve at the National Congress a law that will greatly reduce the number of cases reaching the STJ. This afternoon, President Lula shall sign this law, which is of existential importance, given the transformation that it will carry out here at our court. And so together with alternative mechanisms of justice, including arbitration, this will allow us to improve the quality of our justice and also improve the timelines. I'd like to give the floor to Professor Andres Llana. Thank you. Thank you, Mr. President Benjamin, Your Excellency President Benjamin. It is Your Excellency President Benjamin, Your Excellency Justice Salomão. It is a huge honor to join you today. I'd like to extend my sincere thanks to President Benjamin and the STJ for the opportunity to be here, and also for your valuable support to arbitration. To all who have participated in the organization of this event, and Madam Justice Ellen Gracie for your efforts. I will now move on and to speak English.
Words about ICA. ICA is a worldwide non-governmental organization founded 60 years ago in 1961 in the middle of the Cold War to promote the use of international dispute resolution across borders and across legal cultures. ICA is based at the Peace Palace in The Hague and works closely with the Permanent Court of Arbitration and develops congresses, publications, and projects for the global arbitration community. Our status as a non-profit NGO gives us the neutrality and independence to take up cutting-edge issues and represent many diverse viewpoints. We are a membership-based organization with around 1,000 members from approximately 90 countries across the globe, and we have the luxury of having members as Minister Ellen, Adriana, Dominique, and Eduardo. One of our main activities and our main purposes is what is called the ICA Judicial Outreach Program. ICA's engagement with the global enforcement of arbitral awards and arbitration agreements goes back over 60 years. As one of ICA's founders, Professor Peter Sanders was one of the key drafters of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958, which is called, as we all know, the New York Convention. Since 1972, ICA's Yearbook Commercial Arbitration has published court decisions on arbitration-related court applications from courts around the world, including, as of today, more than 3,000 court decisions on the application of the New York Convention and other key arbitration conventions. Based on this long experience with monitoring the application of the New York Convention and publishing national court decisions from across the globe, in 2011, ICA developed a judicial outreach program, which has two main arms. The first arm is disseminating of ICA's guide to the interpretation of the 1958 New York Convention, which is intended to be as a handbook for judges. The first edition has 29 languages. We recently, 2 years ago, we launched the second edition, which is aimed to have 31 languages, already has 14, and we are very happy, as we do later, to launch the Portuguese edition on this occasion. The second arm is in-person or web-based workshop for national court judges adapted to the practices of the jurisdiction in which are held, known as the New York Convention Roadshow or Dialogues. Since 2012, New York Convention Roadshows have been held in over 40 jurisdictions, and we have been able to have exchanging with hundreds of judges around the globe. The ICA New York Convention Roadshow has different format and extensions, but all of them seek to examine together with members of the judiciary of different countries the convention objectives, purposes, and principles, suggesting methods of interpreting and applying its text in accordance with the best international practice. Throughout discussion among experts and judges, specific issues encountered while dealing with the request for recognition or enforcement of arbitral award or foreign arbitral awards under the New York Convention are identified and further explored. Brazil, Mr. President, is one of the most important international arbitration jurisdictions, with a strong arbitration community and a very sophisticated judiciary. Accordingly, me, on behalf of ICA and as chair of the Judiciary Committee, I welcome and I'm grateful for this opportunity of a fruitful discussion and exchanges that today's event provide us. Thank you very much.
Eu agradeço.
Thank you, Professor Andresiana. And now we will to the conference of the conseiller and Professor Dominique Hacher, that will be moderated by Justice Luiz Felipe Salomão. Justice Luiz Salomão is the Vice President of the STJ, and on the 19th of August, he will become the Chief Justice here of the court. Justice Luiz Felipe Salomão is a great professor in this area of arbitration in our country, and evidently, not only in the theme of arbitration, but in the greater aspects of the civil law or processual law reforms of our legal code. I will exchange places with Justice Luiz Felipe Salomão, because I have an international Congress Brazil-Japan that is happening one floor below us, and at some moment I will have to leave. So I'd rather, as it's being transmitted by YouTube, it's important that we don't have empty spaces in the main focus of the cameras. Due to a logistical issue, I request that we change places.
Bom dia.
Okay, good morning. Firstly, Chief Justice Benjamin, I'd like to say I'm a great joy of participating in such a relevant event to talk about arbitration within the STJ, which is our friend and a partner in arbitration in Brazil. And I'd like to greet you for this initiative and to say my joy is doubled when I see here Justice Ellen Gracie, which is an icon for us, be it of the judiciary power and arbitration. She represents what is best among the magistrates in Brazil. So I'm very happy to be here with her today and to review some colleagues that are very active in arbitration, like the case of Ana Bragueta, who worked with us, and Justice Erling in updating the arbitration law in Brazil and following the international model. It was a period of great learning for me because I was able to work with the best in arbitration in Brazil. In Brazil, in arbitration, we have a success case after the Supreme Court reaffirmed its constitutionality. It's not under the shadow of the judiciary power. It works in a theme where we solve conflicts in an adequate manner. demanding a lot of expertise from the magistrates, and sorry, from the arbiters in certain situations. So we have a system that is very attractive in the international aspect for arbitration, which for us in the judiciary, we have a very interesting observation point. We only examine arbitration when we get a judicial demand to. So it's interesting to see the international success of Brazilian arbitration abroad. So I'd like to say to be able to moderate this panel is a great joy, especially with the participation of a jurist of international knowledge, well known abroad. Justice Dominique Hache is a member of the Court of Cassation in France, international judge of the International Commercial Court of Singapore. Adriana was explaining the system of Singapore of having international judges working in the court, and is the member of the Judiciary Committee of the ICA. And a member of ICA for a long time, with a lot of within arbitration. He has many books written. I was able to check his curriculum, which is very rich. He is an international speaker with many books being published. We are going to hear him with a lot of attention. And I'd like to say that we have here in Brazil a tradition of the actions of the arbitration, and we carried out 2 surveys with the Getúlio Vargas Foundation about arbitration. One of them revealed that our SDJ, we researched that the last 20 years, the homologation of foreign arbitration, 90% were accepted by the court. And we also carried out another survey about annulation of arbitration decisions in Brazil. And this investigation we carried out with the FGV consolidated informations between the periods of 2018 to 2023. And we got to an idea that 70% of arbitration decisions were kept by judiciary power, which is an expressive number, showing the integrity of those decisions. We analyzed especially 3 courts, São Paulo, Rio, and the SCJ as regards annulation. So having said that, let's hear with a lot of attention Professor Dominique Hache. You have the floor, Professor.
Thank you. Thank you very much, Mr. President. Before I start, I'd just like to say how much I'm graced to be here. And I would, of course, also like to say that it's a great honor to be invited to speak at the STG. Monsieur le Président Benjamin, d'abord toute ma reconnaissance pour ce grand honneur. And of course, my warm thanks to the organizers for putting this event together and having me come to Brasilia. Well, if I may now start with my presentation, which I understood as being the judge's role in the review of awards, and I'm understood that you would be more interested by how we can have guiding principles and what the kind of experience they have in that. Let me begin by saying that the judge's attitude towards the arbitration proceedings as a whole determines, in the very first place, how the award will be considered at the review stage. So the first question to ask is, how do you prepare for this in advance? Well, if the courts intervene before the award is made, then you understand that they undermine the arbitrator's role in resolving the dispute and call into question the arbitration clause on which the arbitral jurisdiction, tribunal jurisdictions and authority is based. So there must be a public policy in favor of the award right from the beginning. And when I say right from the beginning, that is beginning with a commitment to respect arbitration agreements. An arbitration agreement is a means of accessing justice from which the parties cannot be deprived unless this would be a denial of justice. Under no circumstances should an arbitration agreement be regarded as an agreement derogating from the jurisdiction of the state courts to be interpreted with caution and on a narrow basis. And only a moderate intervention by the judge, respectful of the parties' wish to entrust the adjudication of their cases to arbitration, to arbitrators or arbitration institution, is permissible. So what I mean is that courts must act in a spirit of cooperation, which means that any form, again, of interference or intervention on their part in the arbitral proceedings must be strictly avoided. Prior to the award, the judge's role should be confined to assisting in resolving difficulties such as those which frequently relate at the outset of the arbitration proceedings to disputes concerning the constitution of the arbitral tribunal, interim measures, or even enjoining the production of evidence by third parties. Courts are merely required to prevent the arbitration proceedings from grinding to a halt when they reach an impasse, whether this is due to an inaction on the part of the parties or the arbitrators, or to a failure on the part of the arbitral institution. The role of the courts is only subsidiary. And that judge's role in safeguarding the effectiveness of arbitral justice is perhaps better understood if one considers this in the light of the policy of giving full effect to the principle of competence. Competence, which we all know, is a principle that enables the arbitral tribunal to resolve all issues arising from the arbitration agreement. Giving full effect to the arbitration clause entails a policy of self-restraint on the part of the court, which suspend its own proceedings in favor of the arbitrator, referring the parties to the latter without determining who is or is not bound by the arbitration clause. Such cooperative policy has a name. It's known as giving priority to arbitral justice over state justice. I understand that this policy has been increasingly adopted, including in Latin America, and notably Brazil. From what I understood, I've been a little bit curious about Brazilian law before making this presentation, but you will certainly correct me if I got it wrongly. You have what you call here pathological arbitration clauses, and if an arbitration clause is so-called pathological because of the prima facie illegality, for example, because the conditions which are enumerated in the Brazilian arbitration law for adhesion contract are not fulfilled, then there is no obligation to refer parties to arbitration. In addition, I understand that there have been further encroachments to the rule of priority to address situations where validity of an arbitration agreement is subject to conditions, and there I really more refer to legislative authorization regarding persons of public law. When assisting the parties in bringing their agreement to arbitrate to effectiveness, presupposes, therefore, the existence of conditions which give their agreement a legitimate basis, an independent and impartial process, consistent with fundamental rights, both in terms of its conduct, that goes to the impartiality of the arbitrators, the guarantees of procedural rights, and with regard to its outcome, and by this I understand respect for values commonly regarded as essential. So this leads me to underline that an award is the expression of a jurisdiction that is, at its core, voluntary and consensual, as based on an arbitration clause that should fulfill the conditions which I alluded to. As a consequence of such consensual nature, the existence of the following conditions, which are more common to most arbitration laws, should be verified. And I looked at, you will see this in the Brazilian Arbitration Act. I refer more particularly to Articles 32, 38. Well, the first is the absence of abuse of power. That encompasses the arbitrator's compliance with the mandate entrusted to them by the parties. It also encompasses the existence of an arbitration agreement and also the conformity of the composition of the arbitral tribunal with the parties' agreement. Second, there must be compliance with the principles of a fair hearing, which guarantee the right to be heard, the absence of arbitrariness, as evidenced by the requirement of reasons in the award, and the impartiality and independence of the arbitral tribunal. And third, there should be compliance with the fundamental values of the legal system of the forum court reviewing the award. Well, what must the courts do? They must ensure, by examining the grounds for setting aside or enforcement that are available to them, and which I have kind of summarized in three major groups, that the award is compatible with their legal systems. But before going into this with more details, please allow me to make a few words on the court's review action and some guidance about this. I propose that the starting assumption should be one of considering the arbitral tribunal as a trustworthy jurisdiction, providing the guarantees of fair trial and offering effective legal remedies to the parties. The court's review action differs widely where the existence of invalidating grounds may only be established by the reviewing courts beyond the reasons of the award, and those grounds where establishment of their existence may run into the impermissibility of reviewing the merits of the dispute. Well, let me begin with the grounds of the first type, that is, establishing grounds for invalidating the award beyond the reasons of the award. Well, there should be, for those grounds, no limitation on the court's power to investigate in law and fact all elements in all matters relating to abuse of power or compliance with the principles of a fair trial, which are validity of the arbitration agreement, including arbitrability issue, independence and impartiality of the arbitral tribunal, reasons for the decision, existence of ex aequo et bono powers, decisions in excess of the limits established in the arbitration agreement, expiry of the time limits for making the award, disrespect of the procedure agreed by the parties, including for the constitution of the arbitral tribunal. Well, in all these cases, this involves ensuring not whether the arbitral tribunal has reached the correct decision or whether it has committed any errors of fact of law, but that it has notably delivered justice to the parties in accordance with the fundamental principles of underpinning fair trial. Contestations of the arbitration agreement, which I referred to, involve reviewing jurisdiction directly, not the grounds of the award. In all cases, the reviewing court may make its own investigations based on all factual and legal elements, as the existence of grounds for invalidating the award cannot be carried out based only on the reasons that are found in the impugned award. I want to say, before leaving this, a few words on independence and impartiality, which is certainly one of the major grounds that must be reviewed by the courts. First, regarding the scope of the court's review powers, ensuring the legitimacy of the award, which is the court's core task, assumes that the integrity of the proceedings was not undermined, and that must include assessing the impartiality and independence of the arbitrators in the context of annulment or enforcement proceedings. And the importance of serving this legitimacy objective does not, in my view, allow curtailment of the reviewing court's power to examine independence and impartiality, notwithstanding the existence of challenges during the arbitration proceedings. There may have been challenges during the arbitration, but the resolution of those isolated incidents by the various decisions on the challenge submissions just cleared the scene at the time they were made in the arbitration. They never purported to and could not, therefore, assess the situation of the arbitrators in the contents of the award. The decisions denying requests for challenges may be taken into consideration by the court, but it remains the reviewing court's role to evaluate the integrity of an arbitrator's situation and comportment during the entire proceedings from the moment the award has been made. The second topic I wanted to address was disclosure. As long as arbitrator appointment is party-driven, ethical concerns need to be addressed to strengthen the arbitrator's independence. And we have recently witnessed a multiplication of initiatives for codes of ethics and guidelines, and that includes the Brazilian, I understand, the Brazilian Arbitration Committee on the arbitrator's duty of disclosure. Well, they all underline the lack of legitimacy of national legislations in the field, particularly that of the law of the seat, which has little authority to govern ethical conduct, as parties cannot be considered to have chosen such law in that respect. However, too many initiatives impair universality. Have these initiatives produced more trust when arbitrators are exposed to more public scrutiny in social media and other channels of information? Disclosures only serve to establish trust. Disclosure is not independence. It is a tool to verify the existence of independence. So the duty to disclose with regard to anything that might give rise to legitimate doubts is broader than exposing matters which would justify a challenge. A failure to disclose does not automatically warrant a challenge. Notwithstanding expanded disclosures on the part of arbitrators who often go beyond the disclosure of actual conflicts with the objective of earning the parties' confidence and faith in their independence, we have seen an escalation in the number of challenges that may be attributed to media activity or tactics, many of which hopefully remain in practice and successful. Well, how the courts can assess, therefore, independence and impartiality with those elements in the background. First, courts should consider attacks on the award against the background of arbitrators' appointments as made by the parties, which makes a significant difference with judges. Unlike judges, arbitrators derive their authority from the parties' will, and this creates an objective link between the parties and the arbitrator, with the consequence that the absolute independence of all arbitrators is an ideal that will rarely correspond to reality. And I must acknowledge the difficulties faced by courts in assessing independence of arbitrators. Flexibility in this work is necessary as compared to the more rigorous standard applying to judges. Looking at the time, I'm fine. I have two examples. I mean, the examples which I'm going to give are really from live practice. I didn't invent them for this presentation, and I have always been surprised by the answers I had. So let me run them. Well, two examples. Contract is as follows, to make things clear. You have the owner in a contract which says that the project manager has wrongfully terminated the contract and that therefore the owner then turns for completion of the works to another contractor. Well, the co-arbitrator nominated by the owner in the arbitration informs the parties during the arbitration of his hiring as counsel in connection to a joint venture which is unrelated to the dispute, but however, he is being hired by a company of the same group of company as the contractor, not a party to the arbitration, but of course related to the dispute because that's the company which should terminate the work. Notwithstanding the co-arbitrator's commitment to inform the parties if anything of concern arose, the arbitrator makes no further disclosure of his involvement in meetings with the joint venture's legal advisors and preparation of an arbitration request for the joint venture, this being only done with limited telephone communication and a few emails. The project manager attacks the award for his lack of independence. Second example, a co-arbitrator nominated by the claimant and his law firm have enjoyed a close professional relationship with the claimant's damage expert and his firm, and they have been working alongside often. The co-arbitrator and the expert have notably acted as counsel and expert for the same party. What should be the test? Well, and I'm using this example to see how we can build an objective test to that. The question to begin with is whether the right to raise the matter was waived because the party attacking the award failed to raise its doubts sufficiently promptly in the arbitration proceedings. In both of my examples, and certainly in the second, there was no evidence that the defendant had not been vigilant enough to have been reasonably been aware of the long and extensive relation between the co-arbitrator and his firm and the claimant's expert and his firm. Then, if this is not the case, move to the second tier, whether the party could establish that a third party or a reasonable party placed in the same circumstances, because what we want to avoid, I think, is a party's subjective impression. Well, whether therefore a reasonable party would find a manifest appearance of lack of independence or impartiality on the part of the arbitrator on a reasonable evaluation of the facts of the case. If I turn to the joint venture, the further work undertaken for the joint venture by the co-arbitrator was held to be foreseeable and as not altering the scope of his involvement with the entity that appointed him. Consequently, we found that the co-arbitrator had not breached his undertaking to the parties to disclose any new circumstances likely to affect his independence, and the award was not annulled. And then, if we have this, if this second part of the test is satisfied, then we may move to the third one, which is whether the manifestly apparent lack of impartiality or independence on the part of the arbitrator could have had a material effect on the award, or was likely to affect the arbitrator's judgment. That was found in the second example, because the failure to disclose resulted in the parties' pleadings and the tribunal deliberating without the knowledge of the arbitrators and his firm relationship with the claimant's experts. However, bear in mind that each member of the tribunal is, of course, expected to have influenced the other two with his views and analysis during the deliberation, and especially when the deliberations were on the damages, then that had a material bearing on the opinion of his fellow arbitrators, and the award was annulled. Aside from the grounds of review, which must be established beyond the reasons of the award, I move now to another question, which is that of the prohibition from reviewing the merits and the other grounds of review. As regards the arbitrator's determination of the merits of the case, two principles should be borne in mind. The first is that the award is a judicial decision which has the force of res judicata, and the outcome of which should not be undermined by reopening the factual or legal grounds of the decision. The second, which is dependent on the first, is to prevent a party from being compelled to relitigate matters that have already been decided in a new trial, so that a party should not be faced, or shouldn't have the burden of being faced with a succession of legal proceedings. Well, the public policy exception is the traditional outlet for dissatisfaction with the substance of the award. So how do we operate the public policy exception and the prohibition of reviewing merits? Well, the two shouldn't be confused. the award must be accepted with its finding of law and fact as adopted by the arbitrators, as well as with the decisions that have been made by the arbitrators. And I've seen this in the Article 18 of your Arbitration Act here. So what the court only needs to check is whether the award, as it stands, is contrary to public policy. So that raises a first question about which standard of public policy. Not infrequently, arbitration legislations and international instruments, I referred to the New York Convention, the Institutional Model Law, envisage the possibility of contradiction of the award with public policy as a generic term. And I have also found this at Articles 21 and 39 of the Brazilian Arbitration Act. Also, I have just a few days before come across your draft law on private international law, and there you referred to public international policy and no more to public policy. Well, anyway, what I think is important is that reference should be made in practice to all the rules and values which the reviewing court forum country considers violation of as being intolerable, even in situations of an international nature. International public policy, now, alike public policy has its roots in national law. Among the principles protected by public policy, or commonly being accepted as protected by public policy, I could cite a prohibition of abuse of rights, of corruption, of judicial arbitrariness, fraud, principle of performance in good faith, mandatory laws, protection of mandatory laws encompassing particularly compelling legislative objectives such as competition or insolvency legislation. I could add consumer protection, President. What matters is the relevance of the law or value with public policy at the time the court rules on the award, and that is to account for the evaluative concept of essential values in society. Well, what I mean is that only a concrete and effective breach of public policy may affect the validity of the award, not something that is only theoretical. So, two broad consequences should not therefore be drawn from the semantic differences between public policy and international public policy. Both are expression of the forum's views on values and rules that must not withstand contradiction. In practice, I will also say that there is a consensus that widely exists that essential values and structuring principles of a public order are the more useful for evaluating the legitimacy of a non-domestic award. I find an interesting example in the recognition of non-motivated awards, notwithstanding the obligation in the arbitration legislation of the forum court to provide reasons for the award, such as your Brazilian Arbitration Act that says, well, award must be motivated. But what really matters for the preservation of the integrity of the forum's legal order is not the presence of reasons in the text of the award, which parties may have waived, or they may have chosen rules that dispense with motivation, but whether the court finds that the decision was not arbitrary. And this is really what should be controlled. I would say the same, for example, for the case of res judicata, which is a fundamental constitutional right in Brazil and is accordingly classified as a matter of public policy. However, the conditions of res judicata in the Code of Civil Procedure may not receive an automatic application in all cases because of party autonomy regarding the arbitral proceedings. The concept of res judicata should, however, that is applied by the tribunal, should, however, not contravene the fundamental policies which protect legal certainty by bringing litigation to an end, while preserving access to justice for all claims and defenses which have not been decided in prior determinations. That is the core of public policy regarding res judicata, even if the Code of Civil Procedure would not be applied. So the public policy exception invites the court to resolve a conflict of rules of law which reflect public policy objectives for determining which ones should prevail over the others. The court should hold a balancing exercise between countervailing public policies. The right to enforcement is not an absolute right, but it is a fundamental right protected by public policy. So therefore, a refusal to enforce an award amounts to an interference with a party's right to a fair trial. And I spoke a few minutes ago about two strong policy objectives for excluding review on the merits: bringing legal proceedings to a close and combating procedural abuse if a party had to return to court to advance the same arguments, claims, and defenses. So the public policies in favor of finality and of upholding international awards, which you see also written, I think it's Article 3 and 4 of the New York Convention, must accordingly be weighed by the court against the essential values constituting public policy which the award is alleged to have disregarded, such as the public policy against illegality, if enforcement of the award would have the effect, for example, of making the award creditor benefit from the proceeds of corruption activities. Now, in waiving the above public policies in relation to the facts of the case as established by the arbitral tribunal, and I'm saying as the facts of the case as established by the arbitral tribunal, because that means that there is no revision of these facts by the court, several factors are available to the court for assessing the appropriateness of reopening the issue of illegality. First, what is the nature of the illegality that is complained of? Was it initial or only supervening or incidental? For example, you have an allegation of corruption in the performance of a contract that is otherwise entirely lawful, or do you have an allegation of corruption relating to the very subject matter of the disputed contract? Well, in both situations, I mean, the allegation of corruption do not carry the same weight. There is also the strength of the case on illegality, whether the case advanced is unspecific or is it based on suspicions and inferences. Then there is also the extent and manner the illegality was addressed by the arbitral tribunal. Has the tribunal determined anything on this? Not all instances justify prioritizing the fight against corruption, particularly when the party challenging the award raises the allegation of corruption only for the first time before the enforcement courts. There is also whether the tribunal's reasoning leads to conclude that the illegality has not been properly dealt with. Protection of property is another essential value which falls within the domain of public policy. Would the interference in the award creditor's substantive right to compensation recognized by the arbitral tribunal be proportionate to the necessity of countering illegality? Not infrequently, public authorities are complicit in the illegality with the award creditor. And here I would like to refer to a case that went before my court, the Cour de Cassation, in a case named after the Latvian buyer, Bielokon, who successfully made a bid to buy a bank in Kyrgyzstan. Following a regime change, the Latvian buyer is expropriated, notably on account of money laundering activities which were facilitated by the overthrown government. The tribunal, having however found no evidence of illegality, ordered the state to compensate the Latvian investor in return for the transfer of the bank shares to Kyrgyzstan. Now, in the circumstances, wouldn't invalidating the award result in a confiscatory solution for the Latvian buyer by allowing Kyrgyzstan to keep without compensation the price paid for the bank properties as a result of the expropriation, the added value between the acquisition and the expropriation, including the profits, of course, generated by the illegal activities, which account for the increment in value? Wouldn't then confiscation exceed Kyrgyzstan's right to the respect of its property? Well, on a balancing of interests approach, non-enforcement of the award would impose a disproportionate burden on the Latvian banker in relation to the objective sought of the fight against corruption. I would perhaps not go into more details, but I would, if there's a discussion, I'll be happy to answer any questions on that. But just let me say that by balancing policies, once again another, what I'd like to stress is that it's not a review, it's not the court that is hearing again the case. The court will use the facts as they have been assessed by the tribunal. Just that the facts as has been assessed by the tribunal are not used to reopen the merits. They are used to do something else, which is which policy should in the end prevail. So the question before the court is entirely different than just reassessing whether the arbitral tribunal was right, whether there was expropriation, whether they found corruption or not corruption. Proportionality, that would be my conclusion on that, reduces the imperative nature of norms to better channel the confrontation with public policy. It avoids a revision of the merits of the award. As a technique of reconciling legal systems to resolve conflicts between norms, proportionality encourages dialogue between courts, and I would like to address this question now. In order to transpose an award, which is an international decision, into a national legal systems, courts should be aware that they are participating in a broader process than simply the enforcement of a particular award. International arbitration, by its nature, is global, just like the trade it aims to regulate. And the development of arbitration within Brazil cannot be divorced from solutions relating to the global development of arbitration. As a consequence of operating on a global scale, courts must demonstrate willingness to place their decisions within the context of foreign and international law to become part of a broader international discourse. Courts should exercise greater initiatives in the application of the law, such as the research of external elements to purely national law that should repudiate any narrow reasoning in the judgments as if they acted within one single national frame. a spirit of openness is needed in the exercise of the court's review of awards. The responsibility of judges is also to network with their colleagues who have the same concerns, face the same problems regarding the quality and security of habitual justice. International tribunals to constitutional courts' decisions participate in the strengthening of the cohesion of solutions. There must be a certain degree of consistency in the review process. Cases must be treated uniformly, even though there is no uniform body of law. And I come there to the application interpretation of the New York Convention that cannot be carried out in a consistent manner, as is necessary for the defense and promotion of the objectives of this treaty, unless judges endeavor to ensure consistency in their respective work. Conversely, giving more weight to the lack of an autonomous meaning of the Convention's provisions under the pretense that they do not set uniform law would otherwise pave the way to upsetting habitual award. And this proposal, which I make, is, I think, even more valid where the New York Convention provisions have been transposed into national law and arbitration, which is applied by the court, such as you do here with the Brazilian Arbitration Act. So regardless of whether rules of international law are incorporated into domestic law, there must be a principle of consistent interpretation that should be used to interpret national law in conformity with international law. And there should be no obstacle to ensuring the respect of objectives and values in assessing the validity of awards. Courts should adopt universally recognized principles. Review of awards must not ignore these rules, which lie at the intersection of several legal orders, such as access to justice, non-discrimination, fair trial, legality, and legal certainty. And I would add rapidly that precisely international arbitration rules, which express unifying solutions tailor-made for international arbitration situations, form precisely the common language with a view to enhancing the functioning of international arbitration. Looking for convergence and common standards is part of an interjurisdictional dialogue which the courts could and should already engage in to find the most efficient solutions and reflect the best norm-based practices. I will not go, I have no time, and I spare your patience also, to go into international arbitration rules. There are many, but those rules are precisely being defined on the occasion of review of awards by courts. My words of conclusions are that courts which purport to exert influence on the regulation of habitual justice should consider themselves as crossroads for exchanges and discussions among legal traditions, cultures, and experience. This is what you have done in generously inviting me to participate in this conversation today, and I thank you very much for your attention and patience. But you give me an hour, so.
I would like to thank and greet Professor Dominique Hache for his for his experience and for his extensive presentation, and speaking about the crossroads and these two angles and visions, which is so relevant in current times. And also in terms of compared law, we have some differences regarding disputes against arbitration in Brazil and other countries, but it's been very interesting to hear this comparison and this examination of all the different facets that you have brought to our attention. I'd like to clarify that we have the pleasure of having the presence here, the attendance of students from UERJ, the the University of the State of Rio de Janeiro. They are visiting the Higher Court of Justice, and they have visited us here today. They're visiting us, so I'd like to greet them and say that we are very pleased to welcome them among us. So let us open for questions. Professor Hasher, shall we check whether anyone has any questions or requests for clarifications, shall we? President Benjamin, thank you. Thank you, Professor and colleague. Dominique Hasher, for the students in attendance, this is a very special occasion, not only because it's a very important topic, but we have the opportunity to hear a speaker for a full hour, because lectures nowadays lectures take 10 minutes at most, even for speakers from other countries. And when, upon the suggestion of Justice Ellen Gracie, when we were organizing this program, when I saw that Professor Hasher would have an hour to speak, I asked myself whether this would be prudent or might even be considered an act of academic cruelty with our guest of honor. But we have had, in fact, a rare opportunity to hear in 1 hour a conference that has provided a very deep overview of all the most relevant issues regarding national and international arbitration. So we are at 12 o'clock. A colleague from the STJ will analyze the very rich experience of STJ on this topic. And for the students, it's important to understand that STJ is the court of international arbitration in Brazil. And in our precedents, we observe some trends, Professor Hasher. First, the growth of the impugnation based on public policy justifications. I am not going to mention them. I hope my colleague Ricardo Vilas Boas Cueva will provide some of these precedents in his lecture. But the most important discussion for all of us is that even though we are speaking about commercial arbitration with its specific features, many of the pathologies that Professor Hasher has mentioned are related to the preservation, not of the interests of the concerning parties, but rather the preservation of legitimacy and respectability of the institute of arbitration. And this is a very important topic for all of us. because just as we, judges, and the product of our work, which is the award, the judicial award, we need to rely on the trust of everyone regarding the legal institute that we have before us or that we have produced. That's why, well, I'm not going to address specifically, but certain aspects deserve attention, not only from the STJ, but other courts that also have the responsibility of confirming international arbitral awards. One of the aspects is corruption. The other is the dignity of human persons, which in commercial arbitration, very rarely we find this kind of discussion. Also, the environmental issue, which increasingly is part of compared debate and international debate, because arbitration has been used as a means to maintain activities that are deeply harmful to people's health, especially to the health of the poorest populations and also to the health of the planet. And so these aspects are left untouched, creating conflicts and disputes that go beyond the specific matter at hand.
But I believe that in the essential of everything that was said here, the intervention of Professor Dominique Hachet is almost like a mirror of what we here in the STJ have accepted as valid in this debate that is not only national. We are national magistrates, but we are dealing with institutes that involve an international understanding in the stricto sensus, but also of the national legal, of comparative law. So I would like to congratulate for the excellence of your presentation, the good sense in all you mentioned. Sometimes a good professor makes a great speech, is in agreement with the law, with the legality, but lacks in good sense, especially as what we expect from the national legal order or international. So I just want to say to congratulate you for the effort you had. And Justice Gracie, myself, and Justice Luiz Felipe Salomão and the STJ, thank you for the opportunity that you've given us of receiving here Professor Dominique Hachet. Still any questions, any doubts? Well, and continuing our program, I thank you once more, Professor Dominique Hachet, and I would like to hand over Justice Ellen Gracie, who will make the presentation of the ICCA guide for judges on the interpretation of the New York Convention of 58. And the first judgment was in the STJ, if I'm not mistaken, from Justice Alberto Direito. Thank you, Justice Salomão. I would like to hand over the floor to Andrés Iena, which is of the Judiciary Committee of ICA. And for the young students that are here with us, I'd like to reiterate our satisfaction in seeing the next generation of jurists already interested in the theme of arbitration and the more ample international arbitration and even more ample of the international law. You're all welcome. Professor Yana from the Judiciary Committee is the person within ICA, and ICA is the one that does the contact with the International Judiciary. And Professor Dominique, he mentioned something which is of the utmost importance about judiciary diplomacy, this necessary exchange of opinions and experiences between magistrates of different countries. So in this land that is one only, that there be a convergence of understanding on the themes that are important. But I would say that Professor Yana has been all over the world seeking this convergence of understanding of a convention that's extremely important, which is the New York Convention. It deals with the applicability of those decisions, be they set in any place of the world. So a arbitral award set in New York can have its execution guaranteed in Brazil, thankfully, due to the New York Convention. But without further ado, I would like to give the floor to Professor Andrés Yana. Thank you very much, Justice Ellen.
To officially launch today the Portuguese translation of the ICA's Guide to the Interpretation of the 1958 New York Convention, which is a handbook for judges, commonly referred as the Judges' Guide. And it's a double pleasure being here with me, with my colleagues of ICA and the Judiciary Committee for this occasion. As the title suggests, the guide was conceived as a handbook to give guidance to judges on the scope, interpretation, and the application of the New York Convention. In order to achieve this goal, the guide aims to be a concise text written in plain language and limited to examination of the most essential aspects of the Convention. The guide is not intended to be a comprehensive reference work, rather is designed to answer specific questions that may arise in the application of the Convention. As drafted, the guide reflects the basic idea that the New York Convention is a simple text that must be applied by courts in the vast majority of the cases by following the plain text of its provisions. Since its publication in 2012, the guide has proven remarkably effective. It has become an influential and often cited authoritative text on the New York Convention. The guide now serves as a tool for judges around the globe, as well as the basic consultation text for academic students and practitioners. The New York Convention is the most relevant and influential treaty of international private law. This can be measured by two essential metrics. The first is that the New York Convention counts with 172 signatories. The second is that there are more than 3,000 judgments that reflect that this text has been applied in most of the cases in a uniform and harmonious way. The treaty and the principle that the treaty embodies have been fundamental in providing the necessary predictability and certainty required by parties involved in cross-border transactions in the recognition and enforcement of arbitral agreements and arbitral award. For that certainty and predictability to be achieved, a uniform and harmonized application of the New York Convention and international arbitration principle is required. And in such applications, the courts have an essential role. They are facilitators of the arbitral process, and at the same time, they are the ultimate gatekeepers of the international arbitration system, as Professor Dominique Hacher has already explained. As a leading commentator put it simply, national court could exist without arbitration, but arbitration could not exist without national court. The international arbitration system depends on courts to compel reluctant parties to arbitrate and to enforce award they refuse to comply voluntarily. By applying the New York Convention, judges around the world not only make decisions in their domestic jurisdictions, fulfilling the role I mentioned before, but also contribute to the development of international law and international arbitration, helping judges in other jurisdictions that can benefit from the case law in those decisions. As Professor Haché already mentioned, it's what we can call the transnational significance of the New York Convention and international arbitration. But is this the duty of judges to give proper application of the New York Convention? It is the responsibility of the international arbitration community to collaborate with judges in this critical endeavor. This is the humble purpose of we are trying to achieve with the Judges Guide we are about to launch in Portuguese version. The guide, very simply, begins with a checklist setting out the questions to be answered and the steps to be followed by courts when applying the convention in two actions available within its scope: a request for the recognition and enforcement of arbitration agreements, or request for the recognition of enforcement of arbitral awards. It then contains 3 chapters. The first one is dedicated to the general aspects of the convention, including interpretation and the guiding principles such as the pro-enforcement bias, and then has 2 chapters. One is dedicated to enforcement and recognition of arbitral agreements, and then there is a second one that is dedicated to requirements made to the court for the recognition and enforcement of arbitral awards. And finally, in order to facilitate deliberation by judges in matters related to the convention, the guide contains 4 annexes: the New York Convention itself, the UNCITRAL Model Law on International Commercial Arbitration, the UNCITRAL Recommendation of 2006 regarding the interpretation of Article 2 of the Convention, and for a number of useful online sources for further reference. As we were discussing yesterday in another event, we are missing one recommendation that was just adopted on UNCITRAL in United Nations on July 6 about the non-discrimination of awards in electronic form and electronic communications in international arbitration. We have a very useful and productive discussion yesterday about the importance of these recommendations, which it seems that we'll have to issue promptly a 3rd edition, before, because the 2nd edition does not contain this basic but fundamental idea that the New York Convention does not discriminate in the form of an award, either it's an electronic or paper base. We hope that this 2nd edition of the guide will continue to contribute to achieving a uniform and consistent application of the New York Convention across the globe. Echoing the word of Professor Peter Sanders, as I mentioned before, who was, is often called as the father of the New York Convention, and who is the author of the foreword to the 1st edition as honorary general editor of the guide, and who passed away in 2012, shortly after the publication of the 1st, we expect that this 2nd edition of the guide will serve as a tool in advancing the mantra he repeated in many occasions, that may the New York Convention live, flourish, and grow, or he liked to say in Latin, and I excuse my pronunciation, vivat, floreat, and crescat, New York Convention of 1958. Before officially launching the guide, I would like to give my floor to my colleagues from the Judiciary Committee and ICA, in turn to Minister Ellen Gracie, Adriana Bragueta, and then to Edu Gonzalez, and they expect to come back to do the official launching. But I want to say one thing before that, which is we do consider in the Judiciary Committee and ICA that is essential that this document, which humbly we consider a simple but important document, will be in different languages, because we think that we need to talk to judges and dialogue with judges in their language. So this is why this is not a translation of the guide. It's a version. It's the Portuguese version of the guide. And we have been taking care that it has been translated, I would say, to put it properly in the Portuguese so judges can, here in Brazil and other Lusophone countries, can apply the convention, having access to the document in, I would say, their own mother language. I hope we have tried, that is free of mistakes. All of our colleagues have to review it. And I expect, humbly as I said, that this will be a contribution and continue to be a contribution for the harmonious uniformity application and also the development of international arbitration here in Brazil. Thank you very much. Minister Tracy.
Muito obrigada, Andrés. Eu agora gostaria de passar a palavra.
Thank you. I'd like to give the floor to Dr. Adriana Bragueta for her considerations, her remarks. Good morning. First, I would like to thank once again this court for its warm welcome. I would also, well, if Justice Herman Benjamin said in the beginning, in the opening, that this court embraces and supports the success of arbitration in Brazil. Justice, thank you. You said that you were able, you pointed out that you were able, in a very busy day, you were able to attend today. And so I've been at the ICCA since 2012, and I'd like to point out the importance, the extraordinary importance of continuing the work of Mr. Vandenberg in addressing one of the priorities of the arbitration community. The ICCA represents the think tank of the arbitration community. One of its priorities is dialogue with the judiciary. Arbitration cannot exist in any country in the world without dialogue, this dialogue. Having said this, I'm hugely thankful to Judge Dominique Hacher, who also has a very busy schedule, coming here to Brazil and giving us this lecture, this valuable lecture. I've been a long-standing admirer of arbitration. When we devised the program, Justice Elling was adamant in terms of I apologize. Now, I am thankful for your attendance. So I was making some initial remarks about the ICCA launch of the guide and remarking on the importance of and Justice Elling's. It was Justice Elling's idea to bring a foreign judge to come and talk to Brazilian judges. I work as an arbiter. I am a lawyer. I'm not a judge. And so Justice Elling, with the support of ICCA, Justice Herman, Justice Salomão, and all their assistants, it is key for them to hear about the importance of arbitration all around the world and the relevance of the judiciary, not from the mouth of a lawyer or someone who is directly interested in arbitration, but rather from a peer, a judge from a different country who has the same concerns, especially regarding public order and ethics in topics covered by arbitration. Professor Hacher, I have already asked my office to transcribe your lecture, and Professor Hacher has spent weeks preparing this lecture. He acknowledged the huge importance of this event and the space and time given to him try to synthesize in 1 hour not only the whole structure of international arbitration, but also the most important points considering the maturity of the Brazilian judiciary. Justice Fátima, for the past 3 decades, has decisions related to arbitration. And so finally, I would also like to thank Justice Herman and Justice Elling as well. Thank you, SEPA, for having helped and supported this event. I have three topics I'd like to address before giving the floor to my colleague. The first is that the New York Convention will celebrate in 2 years its 70th anniversary. So the New York Convention has over 170 signatory countries. It is the private law convention, the most successful one. Nothing compares to the New York Convention. Nothing. In terms of international treaties that have been internalized by the countries that have signed it. And so the New York Convention is very brief. It has few articles. And Professor Philippe Fauchard used to say, he's passed away, but he used to say that it's great. It's very much fit for purpose. It has few articles. It conveys the message very briefly. It specifies the exceptions and limits for non-acknowledgement of an arbitral award, and this allows us, as reflected in the guide, this Article 7 also promotes the principle of maximum efficacy of the circulation of arbitral decisions. And so if there is internal legislation that is more favorable to the acknowledgement of the award, or if you have signed an international treaty that is more favorable to recognizing the award, you can use it. You should use it. This is reflected in the New York Convention. There is world consensus that, in spite of its 70 years and the fact that arbitration is very dynamic, the New York Convention requires no alterations. It represents the state of the art still today. And the guide, I was present when it was launched, its first edition. And so Eduardo Damião also participated intensely. And so the first ICCA event to launch the first guide was precisely here at the STJ to show how important, or the importance that Brazil has in the international scenario. Now, the launch was attended by Professor Albert Jan Vandenberg, a Dutchman, and he was president or chair before Professor Andres Hanna. And so Albert Jan Vandenberg, the president of STJ, was Justice Ari Pajandara. And so I remember that Professor Albert Jan quoted, "We had all studied all the cases decided by the STJ, and Professor Vandenberg spoke to Justice Ari Pajandara. And I remember until this day how pleased the Justice Pajandara was. Brazil is la belle de la classe. Brazil is huge example of success. And that was 14 years ago. Given the maturity that the STJ had in deciding arbitral issues. The second topic I'd like to emphasize, in the words of Albert Jan, and we mustn't lose sight of the importance of what he said. Albert Jan not only in 2012 wanted to say that the Brazilian justice is a guardian of arbitration, or a gatekeeper, as he said, a gatekeeper of the international system. Albert Jan also remarked that the system adopted by our law in 1996 and maintained in 2013, the system of control or review of foreign awards, where other countries have different systems. So where control is exercised and review is exercised by first courts. Now, in our system, we have a perfect system, the best system that can be designed, because it is centered in one court, a court with very experienced judges, and there's no appeal. So it's quick. On the other hand, otherwise, you might have the arbitral award being decided by first instance judges, so he emphasized how fortunate the original legislators were in designing this system. So in 2012, and this is another message I'd like to reiterate, and Eduardo Damião will remember that at the time, two issues were extensively discussed. The delays by the STJ in acknowledging or recognizing the foreign awards. This was adequately addressed when a foreign award is disputed. The time for its appreciation and review has been considerably shortened. And Damião will remember that another message that Albert brought and reiterated by Hannes, the importance of our justices. When they review this topic, in their decisions, they should refer to the New York Convention. So until 2012, for the students here, our legislation, national legislation, has internalized Articles 38 and 39 of the convention. Well, we have copied the New York Convention, but Article 34 on the what applies is the treaty. It's so, strictly speaking, the parties should argue their case when they are discussing approval based not on the Brazilian law, because under Article 34, it's the treaty that applies. And so the parties should argue based on the New York Convention. Since our internal legislation reflects the New York Convention, the justices at the time said, well, the problem is that the parties argue the case is based on Brazilian law.
So it's evident that we as magistrates have to make reference to Brazilian law. But after this date, we saw an increment of decisions and agreements from this court making references to the New York Convention. Why is this important? Due to this international aspiration that arbitration is almost like a justice system or of control that is worldwide. When your awards, when they make reference to the New York Convention, these will be studied by magistrates from other courts to see how Brazil applied an exception of public order, or how Brazil interpreted the incapability of fulfilling that arbitral clause. And the guide, and Andres can give additional comments on that, the guide seeks to bring a bit of that, some examples from other courts. And additionally, this guide, ICA has publications since the beginning in 61. There are many different publications. One is the yearbook. Now it is the editor, Stefan Schild. Vandenberg was the editor of the yearbook for decades. And the yearbook for many years, during many years, brings published arbitral awards, over 600. It brings over 3,000 legal decisions applying the New York Convention and in each one of its articles. And I went to make an analysis of the inventory. We have 264 mentions to Brazilian judiciary's actions. Evidently, you can imagine from many other countries. So really the work, important work that you have here in terms of protecting arbitration, this has a projection to all places of the world. We're not only talking about Paris, Miami, we're talking about Singapore, Hong Kong, Oceania. It is a world system that is supported by the New York Convention, ratified by practically all countries. So those were my comments and ponderations, and I thank you once more for the invitation by this tribunal. Justice Ellen, allow me just to mention the presence of Justice Nancy Adrighi, which is one of great speakers about private law in our country, with a lot of precedents from her rapporteurship. She only arrived now, because she was presiding a panel in the STJ Brazil-Japan Congress. Thank you for your presence. Thank you, Justice Allen. Thank you, Chief Justice Benjamin. I'd just like to say that you're welcome to Justice Nancy. I'd like to say that she's not one of the leaders in general of private law, but she is considered the muse of Brazilian arbitration because her innovative role in building jurisprudence that is more advanced than of many countries. For example, just to highlight one of her decisions where she faced the issue of the coexistence between arbitration and judicial recovery. This is a subject of a lot of doubts, and many countries were not able to solve. And this court has already faced and decided brilliantly in the decisions set by her, and which much honors our meeting here today. Now I'd like to hand over with more responsibility to André Gonçalves for his speech. Thank you, Justice Ellen Gracie. It's always a pleasure to be here working with you and saying good morning to all. I'd like to greet Chief Justice Herman Benjamin, with whom I share a common interest. He doesn't know, but I know, which is environmental law. All that are militants in this area, you are a great national and international reference on this theme, and we know you've led this house, and I'd like to congratulate your presidency that is almost at the end, but made important contributions to this court. Now I'd like also to call to the fan club of Nancia Rodrigues fan club. She does not even she knew she had a fan club in the arbitration. Since I was working in the federal district, you had set very important decisions, and certainly the history of Brazilian arbitration has your name associated, and I think all of us recognize and follow your decisions, which confirming when they're right, and even when they confirm they're not right, they're right as well, because not all arbitral awards should be set. That's why we talk about review in this logic of a restrictive analysis of giving privileges or focus to arbitration, and you focused on this even before you were in this court, and over the years that you've been having this role within the SDJ, and of course, as you are an example for our peers, and I hope that you are a witness of the launch of a very important guide with Professor Andres Hanas, which is the launch of the ICA guide on the interpretation of the New York Convention. A lot was talked about the convention, so I'll limit myself to talk about the guide itself and its importance and its role, which in the case of the SDJ is very interesting. I think Adriana highlighted very well. The guide is made to be read by judges all over the world that apply the New York Convention. It's very small. You can see the footnotes that they offer a list of decisions from many countries that can be inspiration or example, and that can be followed or not by courts all over the world. But like Adriana highlighted, in the case of the STJ, which is already competent already for many years, and that have applied the New York Convention, it's particularly interesting, like Adriana highlighted, the decisions are make part of the list of examples that can inspire judges all over the world. So the guide serves as a reference or something that by the SDJ, but SDJ also supplies content for this guide in its next versions or editions that are part of this roll, this list, this yearbook that brings cases that make reference to the New York Convention. And in this case, it's very interesting that we're launching this guide in Portuguese. As you all know, we've had 30 years of arbitration law in Brazil, and next year, 25 years of acceptance by the convention of which was an important division and now that are referenced in the world. And we all know that if before the arbitration law, Brazil was not seen as a protagonist, now Brazil is a protagonist in the development of arbitration. And as is always important, this only exists when the judiciary of the country, like in Brazil, from the first level judge, the first tier, they have this double function of recognizing the arbitral awards, but will also be the last instance of reviewing the cases. So the function of this court, and if arbitration in Brazil is success, we owe much of it due to the SDJ. So it's a thanks and a request that the SDJ keep this logic and continue to be a foundation for arbitration in Brazil. Why is this guide so important? Because despite the success of the New York Convention, a treaty that is ratified by over 170 countries also has a risk that there not be a certain harmony in the interpretation worldwide on its items within what are the basic items of the New York Convention. A formal review that is very restrictive. We have in the 5th article, we have 5 cases of the non-recognition of arbitral awards from abroad, and the STJ followed this, and the world as well follow, which is a very restrictive review applying those causes of non-recognition in a very limited way and not amplifying. So giving, privileging the rules based and being pro-arbitration. Why is it important? We heard from Professor Dominique Hacher, one of the most, which is this role that even though the courts of each country are interpreting and applying the law within that jurisdiction that are dear to the international, like is commercial arbitration, and the role that they develop in a world that is more and more lacking of a global multilateral vision, it is very important that the courts of each country be also the guardian, not only on a view about the public order and the commerce and its impacts in Brazil, but also respect to international commerce and a vocation, as was said by Justice Herman, that is some moments where you want to question the arbitration through the bias of public order. Always is very important to see a court like the STJ looking at this issue in international arbitration with an international public order that privileges the local interests of all affected, not only just the big commerce or big companies, but to stimulate a healthy development of international commerce that is so dear to Brazil and the insertion of our country. And in a world that has sought, but has unfortunately gone or has focused in unilateral means. And the guide talks about this, that this treaty has this function and it's more ambitious. It's not only talking about harmonization, it has an ambition, the uniformization of the interpretation of this convention that is so relevant for international commerce and the future of arbitration as a whole.
It's interesting that the guide, we will have the formal launch and of the guide, and Chief Justice, it will also be given to all the justices of the court, and it's a very interesting consultation material. And it goes over all the questions that all the courts answer. So the scope of application of the convention, formal requirements for acknowledgement, what are how to balance with the principle of favoring enforceability. And so it's already been translated by over 30 countries. In Brazil, we had a very talented group working on the translation, but it's not an abstract treaty. In practice, it's almost a decision roadmap. So it offers to the court that consults it a compared point of reference before making decisions. And so it's interesting. And I admit I had failed to see it, but in 2015, in a decision by Justice Jorge Mushi, referred to the convention guide, the first version of it, in a flagship case known as 567, the EDF case, on the attempt to acknowledge an arbitral decision in the country of origin. And so with reference to the New York Convention and how the guide interprets the convention, Justice Jorge Mushi was the rapporteur and responsible for the non-acknowledgement of the award at the time, rightly so. And several other STJ decisions that in cases of violation of public order, where there was no evidence that the party had been able to participate in the arbitration, which is a basic principle, and reinforcing that not always acknowledgement is the right path. That's why the role of gatekeeper of STJ is so important. And there are decisions, as we will hear from Justice Cueva. The STJ made the rules, the citation rules, more flexible, understanding that in international arbitration, these rules should follow the legal form rather than the Brazilian legislation. And so showing the importance of a uniform view and thinking of international law so this other lens that STJ contributes to, so that judges all around the world can also look at STJ decisions and use them as a basis for interpretation and decisions. And so I'd like to conclude now saying that the ICCA has a double role or the guide has a double role of providing an interpretation roadmap that has been tested internationally, helping to also preserve the enforceability, and the STJ, with its vast jurisprudence, can contribute actively and constructively to the uniformization, not or as part of the global jurisdictional dialogue that confers to the New York Convention its practical applicability. And so producing jurisprudence and also the interpretation role that explains why Brazil is known as a strong supporter of arbitration all around the world. And the work of the STJ needs to be studied, not only by us in Brazil, but also as a live part of the comparative law. And so let us continue on this successful path of successful interpretation of the Convention of New York and Brazilian law on arbitration. Thank you for the opportunity. And I'd like to give the floor back to, so I'd like to hear the words of my friend and colleague and a friend of arbitration, Justice Justice Nancy. Thank you, Justice Ellen Gracie. For us women, you have always been a paradigm. We all want to be like her and how she was at the Federal Supreme Court. Thank you for the opportunity to greet the foreign professors that have joined us here and to hear such important information as what I've heard thus far. Thank you for the opportunity, Justice Ellen Gracie. I'd like to greet all the students and participants of this event who have been collaborating to the growth of the area of arbitration that I've admired for so long. Thank you. I'd like to give the floor back to Professor Andreas Hanne.
Ellen, Minister Ellen, I think it's a real pleasure to be here with all of you today. I want to say that we always knew the importance of Minister Ellen in the Judiciary Committee. She's a member of the Judiciary Committee for many years. Now, and not only know, but also understand the importance that she has. And we are, really honored and proud of having her in our Judiciary Committee, as we have also just Dominique has shared. For us, it's very important to have people that have been in the judiciary to understand properly our role. Before proceeding to the official launching, I simply want to make two final remarks, which is simply a repetition of what we have been said by my colleagues. The first one is to reinforce and repeat that in ICA and in the arbitration community, and I think I can speak of the international arbitration community as a whole, we do deem that the dialogue and exchange with judges is the most important task that we have to do. We can talk to ourselves, of course. We can believe that ourselves are right. But as I said at the end, our real test is that the judiciary of different jurisdictions understand the principles of international arbitration and share them. I think you mentioned, President Benjamin, the importance of legitimacy in what we do. And we are humble in international arbitration to understand that our task to prove the legitimacy of what we do is always needed and present. And having the opportunity to speak to judges of this high level on such an important jurisdiction like this really, goes to the heart of what we consider, as I said, is it's our essential task, and the Judiciary Committee that I have the honor to consider, as I said, is the most important thing that we have to do. The second thing that I want to mention is to reiterate that when the Superior Tribunal de Justicia makes a decision on the New York Convention, it's not only resolving a matter at the domestic level, it also contributing to the development of international law and international arbitration. Judges around the world can benefit enormously, as have been said by my colleagues before, from your judgments. And as I said, it's very important that every time you issue a judgment, that judgment will be part of a repository of international decisions that will conform not just, as I said, domestic jurisprudence, but international jurisprudence. And we appreciate that contribution. Thank you very much again. And now, let me proceed to, as I said, to the official launching, if you allow me. We are delighted to officially launch, I would call, the Portuguese version, not translation today. And I would like to present a copy of the second edition that I have the privilege within the Judiciary Committee to lead, of the second edition of the Judge's Guide in Portuguese to you, Excelentísimo Señor Presidente Benjamin, if you allow me, the honor and the privilege. And also, and also to the Excelentísimos Ministros and Ministers, we have a copy as well. I took the liberty to put there in the screen. As you can see, we have a QR code. We try to be modern to the extent possible. And the edition is also online, freely available to anyone that would like to access and to use it, in a digital or electronic form. So having said that, and with the benefit of my colleagues, I consider that we are officially launched. We always like to take a photo to make a remembrance of the moment. But if you want, we can do it at the end, with everybody will be present. Well, obrigado, muito obrigado again. Thank you very much.
Eu agradeço a você. Agradeço a você. Posso? Tá encerrado isso? Não, eu sei. Não, tá aqui já o próximo. Eu queria, já posso passar para o próximo. Bem, eu queria
To thank Justice Elling. I would like to thank Professor Andressiana and Dr. Adriana Bragueta and Eduardo Damião Gonçalves for the launch of the Portuguese version of the guide. I have already observed that it's Portuguese from Brazil, which makes it easier for us. We don't have anyone from Portugal among us here today, so let us acknowledge that there are differences between Portuguese from Brazil and Portuguese from Portugal. Now, we cannot say this. Now, we shouldn't say this because we are live on YouTube, right? And we mustn't make this kind of remark. So, in concluding this panel, and shortly after I will introduce the moderator and speaker of the last panel, it's important to mention why Brazilian judges do not, as a rule, quote international conventions. Our guests might imagine that it is prejudice against the New York Convention, But in fact, it isn't. Other conventions and secretariats complain that we judge well and we apply very literally texts from a particular convention, but we forget to quote the text of the New York Convention. In environmental law, this is very common, and there are dozens. 350 MEs, not only conventions and international agreements in general. And at the Higher Court of Justice, we have hundreds of decisions in the environmental area, but quotes of the Convention on Biodiversity, Convention on Climate, just to mention two of the most relevant, they are extremely rare. Now, the reason is that Brazilian law, contrary to what occurs in other countries, we incorporate not only the literally the international texts, but in our internal law, we go beyond. And so the Brazilian judge doesn't feel the need, as in other countries, to quote the convention.
In the case of the New York Convention, like Adriana mentioned, there is a loss because if we do not mention the convention and the specific legal device in a concrete case, the repertoire, international repertoire, will not have conditions by literal mechanisms of associating the Brazilian decision to that international law or convention. So we are getting into the era of artificial intelligence, and here in the SDJ, we are using it a lot, but that's for a future debate. The president of the IT Commission and also artificial intelligence, which is Justice Paulo Domingues, who moderates the next panel. We have conditions to extract from those decisions from the SCJ for commercial arbitration, even those that do not refer directly to the New York Convention, through the interaction with the text and which devices were mentioned or which disposition. So we should make this the work of artificial intelligence easier, mentioning that article or disposition or device. Well, why not mention the convention? So with this small explanatory note, here only justice of the court can give internal reasoning. It's almost like a deviation in how we rule these, but with no loss to the decision. We are the ones who can do these explanatory notes during our work. Okay, so I'd like to thank to the members of the panel. We will go to the last one, which has a moderator, Ms. Justice Paulo Sérgio Domingues, and I will ask Justice Adriana to change with him. Moderator is Justice Paulo Sérgio Domingues. The speaker is Justice Ricardo Vilas Boas Cueva, that I will ask Adriano to change places. We have a Justice of Private Law, which in the French experience would be a judge of the State Council in France. Justice Paulo Sérgio Domingues got to the STJ coming from the Federal Justice in São Paulo, and is the only justice that was the president of the Federal Judges Association, which is the entity that joins or that joins all of the federal judges. We have members from the Federal Justice. Justice Ellen Gracie made her whole career basically in the federal justice and in the public prosecutor before that. And Justice Ricardo Vilas Boas Cueva was from the second session, which would be the corresponding to the French Court of Cassation. We also have the part of penal law, which would be the third session. He is a great specialist in the theme of arbitration. Both are doctor in law in Germany. We're not discussing German law today. Therefore, your knowledge of German law is deep, might not be necessary in today's debate, but your knowledge of comparative law and of the convention and arbitration in general equally. So, Justice Ellen, I'll hand over to the moderator, Justice Paulo Sérgio, but due to logistics, since I will have to close the Brazil-Japan convention, I will have to change places. So we do not have a physical, so we can keep the panel continuous. I'll just stay a little bit more. Yes, good morning, dear Chief Justice Herman Benjamin. I would like to greet Mr. André Janas from the ICCA, Justice Ellen Gracie, my colleagues, Justice Nancy Andrighi, Mr. Cuevas, all of present and here and online on YouTube, and Justice Ellen Gracie, which was our president in the Supreme Court for so long. But in a quick word before we start the debate, I'd like to greet once more President Herman Benjamin. His administration, among many things he accomplished and was able to do in STJ, his administration was focused in the international arena with many international events, and the role of the court in many different seminars like this one that show how the insertion of the STJ is in the international scenario with this connection, Brazil to other countries. He carried out dozens of these, and a few days before the end of his term, we have 3 events happening, 2 this week, 1 next week. So I would like to greet you and congratulate you in how you act and the spirit of justice. So a round of applause. The theme here is very relevant, as the previous presentations have shown. the second session of the court has given lessons effectively on the application of arbitration and giving more and more security of those that seek arbitration and how it will be interpreted in Brazil. This is the way in which the court has taken the role it was given and how they have tried to reinvent itself and acting in all areas. Here, as someone who is outside the public law, I would like to highlight those who work with private law here in the tribunal, in the court, especially the talk about international kidnapping of children, but many of the themes that are more and more relevant in our current scenario. I will now hand over to Justice Ricardo Cueva, a colleague from the University of São Paulo and the Greater University of Frankfurt, for his speech on the experience of the STJ in recognizing arbitral awards from abroad or from the canceling of sometimes the Brazilian arbitral awards. I'd like to greet once more our Chief Justice Benjamin Herman, and also like the moderator complimenting his brilliant 2 years at the head of the court, to greet Justice Gracie, who in many occasions I was able to share with her the experience of arbitration, especially here in STJ. I'd like to greet Deborah as well. On the 17th, we will have the opportunity to speak in São Paulo once more on arbitration. We have every year an observatory on arbitration here in this room, and this is the third or fourth time we do it. On the 17th, we will be in São Paulo for that. Fundamentally, the judges from São Paulo about the measures that unfortunately go against these awards. I'm going to talk about the 20 years of arbitration within the jurisprudence of the STJ. We know that arbitration is an experience that has unconditional success in Brazil, and this is fundamentally due to the STJ. No false modesty in that case. The STJ has had a jurisprudence that started with a certain skepticism, and now we have ample approval. When we talk about arbitration abroad and the approval it deserves here, and it deserves a certain level of skepticism, because in our jurisprudence, 99%, even more, of the issues brought to the STJ end up deserving approval. There's no parallel in the world. Where you have this level of approval. In terms of giving example of this enthusiasm, the second session of the STJ, which usually judges these issues, in 2013 pacified a theme that was controversial, which was the possibility of the court between competency between judges and arbiters. And more recently, we see important judgments for the establishment of well-defined limits of the competency of arbitration judges as well as subjects as the form in which arbitration is carried out in Brazil and between the competency between arbitration trial judges, the of having to reveal these arbiters or to be transparent, and the limits of the competency of these arbitration judges, with those that involve judicial recovery. In the last legal reform, it's over 10 years already, on the creation of a policy of mediation and conciliation that is obligatory, that was inspired on the success of arbitration that has been proven during the process, especially the Supreme Court's judgment about the constitutionality of arbitration. The Civil Code process of 2015 that has in the articles 119 and 191 the conventions that are atypical.
And this ends up creating a mechanism of healthy competition in arbitration. And it's being used very creatively by legal counsel, legal and lawyers to achieve possible healthy competition, to the extent that specialized chambers and courts can adopt rules to reduce the time frames of the procedures. And so in the 90s, before the law on arbitration, we already had timid jurisprudence on arbitration, which was detected at the STJ. But after Amendment 45, STJ began to acknowledge foreign awards. This had always been the competence of the Supreme Federal Court, but that's when robust jurisprudence on arbitration began to be developed, and conceptually, the main elements and characteristics of the institute were established. One of the most controversial cases on arbitration judged here at the special court was the Bengoa case, questioning the validity of the foreign award and involving impartiality of the arbitrator, considering the prerogative of impartiality of the judge and applying in observance and resulting in direct offense of violation of national public order. And so the Brazilian court would have the right to decide on the topic. And so this was judged under the rapporteurship of Justice Fischer and Justice João Otávio Aran, with a memorable vote by Justice Nancy Andrighi. It was a case that was criticized at the time, but it was a milestone for having established the notion that impartiality of the arbitrator is an essential characteristic. The notion of public order and sovereignty, national public order and sovereignty. So recently, in December 2025, the special court, in judging a case related to Ukraine, approved acknowledgement of a foreign award in the case of a binational company between Brazil and Ukraine, the Cyclone 4, and denying the claims. And the case was understood as not violating public order, and the rapporteur pointed out that the arbitral award did not impose any obligation to the federal union, but rather to a legal person. The result, the transfer was determined, and pointing out that the Convention on the Elimination of Need for Legalization of Foreign Documents enacted, and the normative procedure that certifies the authenticity of a public document for the use of signatory countries, simplifying the bureaucracy and substituting the consular legalization. This has been recognized by the STJ, which facilitates the acknowledgement of arbitral awards from abroad. Lately, some important decisions have been made regarding pre-arbitral decisions. And the links between state justice and arbitral justice are basically the arbitral letters and awards and execution and enforcements, and so the hypothesis where the judiciary branch is called upon to decide on arbitral issues. And so regarding the cautionary measures, the competence of the arbitral judge before the arbitral procedure, the cautionary measures to avoid or to ensure, so the efficacy of the judge defines whether the cautionary measure will be maintained or revoked. Regarding prior measures to arbitration, the third group of the STJ has already examined the hypothesis of producing evidence before as decided by Rapporteur Justice Belize and followed by the conflict of competence reported by Justice Moura Ribeiro. So after this, based on this judgment, the arbitral chambers began to organize more efficient procedures for designating arbitrators, and this contributes to the designation of emergency arbitrators, contributing to the improvement of the Brazilian model. The annulment of arbitral awards and competence conflicts are also a fertile field for the judiciary branch to establish limits to the development of arbitration. Objective arbitration and subjective arbitration are recurrent topics in these cases. The issue was addressed in a case reported by Justice Nancy Rodrigues and judged in 2020 in the second session. The case of Petrobras, very controversial, deserving a lot of criticism. and involving an arbitral clause inserted in the bylaws of Petrobras, with the second session having decided that even though it would be possible to adopt arbitration by public administration, as well as arbitration of the company's relations, the extension of the arbitration procedure was not extended to the federal union as major shareholder of Petrobras, given the absence of a specific law authorizing this, and so the subjective arbitration. So in the hypothesis analyzed in the subjective case, and so it was a case that involved intertemporal law, because there wasn't a law, an authorization law, and it was very controversial and criticized in the doctrine because there was an absence of an authorizing law, but it's what the section decided at the time. So the vote of the rapporteur prevailed. The limits of the competence involving companies in judicial recovery
Was also a theme that was discussed by the third session by the view of arbitration, recognizing subjective arbitration that involved and others in affirming that the compensation involving credits that could be judicially recovered, this could not be considered a patrimonial right due, and that this could not be done through arbitration, objective arbitration. This was judged in 2025, but the second session of which I am part, and it was told to me that there wasn't any precedent that talked about the possibility of having compensation in that possibility. As regards the possibility to submit to insurance, there was an interesting case in 2023 was carried out by Justice Nancy in 2023 in the third session, decided that the insurance company should be submitted to the clause set with the person that bought the insurance. And due to that, the competency to judge this demand will be in the arbitration and dealing with the maritime law. The STJ understood that this clause couldn't be used because in that case, the situation was different, and the person that was insured that was asking for compensation wouldn't have had a contract where you would have a clause in that aspect. This was, and in terms of conference between arbitrary and in terms of jurisdictional nature, even if they're set for the same arbitration, this shouldn't be subject to disciplinary judgment. And this is a very specific, peculiar judgment. It's a very well-known conflict. The Article 246 and in B3, is not subject to a solution in its statute. So it is not possible to have a solution for the judiciary power was called upon to this problem in arbitration. I think it's the only one in the world where the judiciary power was called to have a solution between different chambers. And it was called to do so and found a solution for the conflict of competency between these. As regards judicial review, in Article 43 restricts in many formal aspects. In Article 32, and you cannot exclude merit, especially in terms of the proof or evidence given. So I remember the third session decision, also by Justice Belize. And in the case of the annulling, and that the idea of the arbiter of revealing the facts that could put doubt on his independence or being unbiased, or the lack of independence, then the judicial power has to see the relevance of the fact that was not revealed to decide to annul or not. And we've seen many different cases that have been annulled, and with annulation of the arbiter that has worked as a kind of institutional nudge for the institution of arbitration. And in many ways, this has improved the questioning of arbitration institutions and has worked as an improvement of arbitration in Brazil. It's been more careful how questioning has been done, more refined or improved, and arbitration has been looked at with a closer look and a dialogue with the judiciary power that we've seen in the last 30 years. It has worked to satisfaction, and I think that these annulments serve to this purpose of improving institutionally the arbitration. As regards the execution that was celebrated, and they mentioned some of the judgments, and the STJ already decided that once 90 days have gone, both sides cannot attempt to annul through of that arbitral award, because having ended the period where they could do so, as said by Justice Nancy. So in conclusion, we could say that the jurisprudence of STJ, especially after Amendment 45, where increased the number of cases seen by the court, going to a solid affirmation of arbitration as an adequate manner of solving conflicts in Brazil. And this demonstrates that the precedents of the court have been coherent in keeping the central aspects of arbitration as defined in the law and international convention, and the recognition of the autonomy of arbitration, be it in the modes, has assured that it is a binding decision, and this has been reaffirmed that arbitration, as regards the judicial review, as well as the possibility of the competencies of state judges and equal footing as concrete laws or conflicts between different fora. So the trust mentioned in the beginning doesn't mean there's a lack of review the examination of impartiality and of revealing of biases, even though impartiality is an issue of public order, the STJ has a pragmatic view that the issue might not be a problem, that it just has. So looking to the future, the jurisprudence goes to a fine attunement period and trying to avoid automatic application of the competency in terms of arbitration when necessary among jurisdictions has to be seen as communicating with different areas, like in the objective and subjective arbitration in disputes, especially in judicial recovery. So in summary, SDJ consolidated in the last 20 years as the guardian of the arbitration system, reinforcing the institution while recognizing that they need occasional correction of the model installed in Brazil. Thank you for the patience of all. Thank you, Justice Cueva, and to hear his deep knowledge of the theme, but the important cases and examples he brought as someone from the doctrine. So I'd like to question if anyone in the panel would like to speak up or ask. Okay, thank you. I would just like to greet Justice Cueva for his brilliant presentation on the jurisprudence of the SDJ, and to say when the court's magazine or newsletter was launched, I was thinking, what could I approach? And I remembered of the fundamental importance that the jurisprudence in STJ have for the development of arbitration in Brazil. And in this small summary, I relate a series of cases that will define important, very important cases, be it for arbitration or for the recognition of foreign arbitral awards. So this concern I've always had of demonstrating how important what Brazil has to offer the world in terms of knowledge as regards arbitration and the recognition of arbitral awards from abroad. Within the New York Convention, I congratulate Justice Cueva for this updating on jurisprudence and some important cases. Thank you very much. Thank you very much. I told Justice Nancy that she should be able to answer to at least a dozen of these mentions. I remember Justice Cueva, in the beginning of the year, in the first session, we had an issue. One of the cases examined was about arbitration, where the contract that had a clause was a railroad company that was integrated by the federal railroad network and then incorporated into the union. When we wanted to do this arbitral clause, they said it was impossible because the union didn't have legal authorization to use arbitration. But it's been for a long time. But they said we can't use it because it was before this happened. And there wouldn't be legal authorization. We said, no, that's not the case. It's not about voluntary submission, but when we incorporate something, we incorporate everything, the rights and obligations, and we understood, yes, they could use the arbitration clause as an example of success. And with AGU, they are very enthusiastic about using. There's a sector dedicated with prosecutors that dedicate themselves with this with a lot of competency and showing that arbitration, especially in the public sector, has created a story of success that is very important. It's an old contract, probably won't repeat itself, but it is interesting to mention. When I was in the university in the 80s, Professor Guido Soares, arbitration was a dream. We would never imagine that arbitration in Brazil would consolidate because we studied those old cases in the Supreme Courts, the Ju and other cases never worked out. And
In also conciliation and other dispute resolution mechanisms, the dogmas of public interest prevented this discussion. So we've evolved greatly in these decades. If you allow me, Justice Dominguez, I would like to refer to, in terms of alternative dispute resolution, but more prevention. We need to adopt prevention. And we've been developing the dispute boards, those commissions that review long-term contracts as they unfold to prevent conflicts, big conflicts that will require arbitration at the end. And so along the execution of long-term contracts, infrastructure contracts, for instance, and other maintenance contracts. The maintenance contract of the STJ with the technology company that supports it, for instance, it's a long-term contract. And at some point, any contract will present some conflict among the parties. And so that's where the dispute board comes in, a group of experts who immediately issue a decision and indicate a solution. And so this is the future, I believe. We in the judiciary, in arbitration, and other dispute resolution mechanisms, we arrive ex post, but we need to act ex ante before the dispute arises. And that's an important market for the new generation of legal experts. Be watchful that there is a role to be played in this market.
Mr. Dominguez, I just want to say that I appreciate the presentation that you just made, Ministro Cueva. Is very informative and educative. Of course, we know the importance of the decisions of Brazil, but I wanted to mention something that maybe is less known. I think Adriana mentioned this. When we talk to other judiciaries or we talk to other parties in the world about international arbitration, we usually say, and this is the case of Latin American countries as well, there are two basic requisites for arbitration to develop in a given jurisdiction. The first one is that the jurisdiction has the proper international arbitration framework or arbitration framework. You need the proper law, right? And you have on one hand the New York Convention, which is obviously we have discussed about it today. On the other hand, a good international arbitration law like the model law or based on the model law. But that's not enough, you know, because without an application of the judiciary of that shared principles of international arbitration, a jurisdiction would not be able to develop. And I remember when we have a meeting with the judiciary in Spain, and was Edu Gonzalez there, we explained how Brazil is the best example that in 30 years, Brazil was able to go from almost no arbitration to one of the most successful countries in terms of arbitration. I mentioned today or yesterday that Brazil in terms of ICC must be second or within the top 5, and 37% of those cases are with state entities, where the average in the ICC is 20%, so it's double. So that shows how the proper interpretation and application of the international arbitration principles is really the recipe for the development arbitration in a given country. And Brazil is presented as an example of that. You just not need only good law, you need basically a good application of the law. And to finalize, international arbitration works in the understanding that has been some uniformity and harmonization. Shared principles are basic. You don't want, if you go to a different country, in a different legal culture, you don't want idiosyncratic things. What you want is to have a common language. And law is a form of language. You know, maybe it's time to finish, but you know, no, it's a common language. And the fact that the tribunals apply that common language in the proper way is what makes arbitration successful and possible. And I want to commend again the work of the Superior Tribunal of Justice is an example in the world of that in a short period of time. And I want to appreciate again and be grateful for the recent presentation, and thank again to all of you for giving us the opportunity today to talk to you and extend this and have this unique and extraordinary opportunity to exchange views of international arbitration. Thank you very much. Thank you very much again. And again, I want to, on behalf of ICA Judiciary Committee, thank you for receiving us in this magnificent building. Well, all the people that are here, you know, that have attended us. I want to say Sebar also made this possible as well. Thank you very much to Deborah and all the colleagues that work very hard for this organization. Adriana, Dominique, that traveled for 1.5 days, Dominique, I don't know, maybe it's close to 2 days only just for this event, and in particular to Mr. Ellen, that member of our Judiciary Committee, that was the heart and soul behind this effort, which is, as I said, a unique and extraordinary opportunity for all of us. Thank you very much again for this opportunity.
Muito obrigado. Muito obrigado. Eu, mais uma vez, agradeço ao ministro Ricardo Cueva por sua exposição. Agradeço ao professor André Jana, também como presidente do Comitê Judiciário do ICCA. O ministro Dominique Acher, agradeço também pela presença e participação. A ministra Ellen Grace, e devidamente autorizado pela ministra Nancy Andrighi, eu agradeço a participação de todos e dou aqui por encerrado o painel e o seminário. Muito obrigado a todos.
Excelente. Foi bom. Foi bom, excelente. Mais que bom.